Today we shall be talking about Florida's government and the Sunshine Law, commonly referred to as the Sunshine Law, which is codified in Chapter 286 Florida statutes. The Sunshine Law provides a right of access to governmental proceedings of public boards or commissions at both the state and local levels. The law is equally applicable to elected and appointed boards. The law is applicable to any gathering of two or more members of the same board to discuss some matter which will foreseeably come before that board for action. Now you need to remember there are three basic requirements for the Sunshine Law. Number one, meetings of public boards or commissions must be open to the public. Number two, reasonable notice of such meetings must be given. And number three, minutes of the meetings must be taken and promptly recorded. As stated by the Florida Supreme Court, the Sunshine Law is to be construed so as to frustrate all evasive devices. Advisory committees created pursuant to law or ordinance or otherwise established by public agencies may be subject to the Sunshine Law even though their recommendations are not binding upon the agencies that created them. A limited exception to the applicability of the Sunshine Law to advisory committees has been recognized for advisory committees established for fact-finding only. A committee is not subject to the Sunshine Law if the committee has only been delegated information gathering or fact-finding authority and only conducts such activities. However, when a committee has been delegated a decision-making function, i.e. sorting through options and making recommendations to the governmental body, in addition to the fact-finding, the Sunshine Law then applies. Moreover, the fact-finding exception does not apply to boards that have the ultimate decision-making authority. Thus, a board cannot take a fact-finding tour regarding an agenda item which is either pending or reasonably anticipated to come before the board in the future without compliance with the Sunshine Law. Generally, the Sunshine Law does not apply to private organizations providing services to a state or local government unless the private entity has been created by a public entity, there has been a delegation of the public entity's governmental functions, or the private organization plays an integral part in the decision-making process of the public entity. Private corporations which perform services for a public agency and receive compensation for such services pursuant to a contract or otherwise are not, by virtue of this relationship alone, necessarily subject to the Sunshine Law. What matters most is whether the public agency's governmental or legislative functions have been delegated to that private corporation. The Sunshine Law can apply if the public entity has delegated the performance of its public purpose to that private entity. Meetings of staff members are not ordinarily subject to the Sunshine Law. However, when a staff member ceases to function in a staff capacity and is appointed to a committee which is given a policy-based decision-making function, the staff member then loses his or her identity as a staff member while working on that committee, and the Sunshine Law then applies. It is the nature of the act performed, not the makeup of the committee, or the proximity of the act to the final decision, which determines whether a committee composed of staff members is subject to the Sunshine Law. When public officials delegate their fact-finding duties and decision-making authority to staff members, you need to remember that those individuals no longer function as staff members, but rather stand in the shoes of such public officials insofar as the Sunshine Law is concerned. So the staff member needs to be concerned about that, and so does the public official making the delegation, prior to the delegation being made. Occasionally, members of public boards also serve as administrative officers or employees. The Sunshine Law is not applicable to discussions of those individuals when serving as administrative officers or employees, provided such discussions do not relate to matters which will come before the public board on which they serve. Thus, a board member who also serves as an employee of an agency may meet with another board member on issues relating to his or her duty as an employee, provided such discussions do not relate to matters that will come before the board for final action. The Sunshine Law extends to discussions and deliberations as well as the formal action taken by a public board. There is no requirement that a quorum be present for a meeting of members of a public board to be subject to the Sunshine Law. Instead, the Sunshine Law is applicable to any gathering, whether formal or casual, of two or more members of the same board or commission to discuss some matter on which foreseeable action will be taken by the public board. A board member may, outside a public meeting, send documents that the board member wishes other members of the board to consider on matters coming before the board for final action, provided that there is no response or interaction related to such documents among the board members prior to the public meeting. In such cases, the records, which are subject to disclosure under the Public Records Act, are not being used as a substitute for action at a public meeting, as there is no interaction among the board members prior to the meeting. If, however, a report is circulated among the board members for comment, with such comments being provided to other board members, there is interaction among the board members which would violate the Sunshine Law. Similarly, board members may not use computers to conduct private discussions among themselves about board business. Thus, for example, while a board member is not prohibited from posting comments on the city's Facebook page, the board members must not engage in an exchange or discussion of matters that foreseeably will come before the board for final action. Board members may share a laptop computer even though the hard drive of that computer contains information reflecting ideas of an individual member or as a means of communication between the members. A city board is not authorized to conduct public meetings via electronic media technology, for example, telephone or video conferencing. The Attorney General's office has advised that the authorization contained within Section 120.54, subsection 5B2 Florida statutes to conduct meetings entirely through the use of communications media technology applies only to state agencies and not local governmental entities. Hence, a quorum of the local government board must be physically present at each meeting. If, however, a quorum of a local government board is physically present at the public meeting, a board may allow a member who is absent with health problems to participate and vote in board meetings through the use of such devices as a speaker telephone that allow the absent member to participate in the discussions, to be heard by other board members and the public, and to hear discussions taking place during the meeting. The physical presence of a quorum has not been required, however, where electronic media technology, such as video conferencing and digital audio, is used to allow public access and participation at workshop meetings where no formal action will be taken. No formal action. Thus, the Attorney General's office concluded that local boards may use electronic media technology to conduct informal discussions and workshops over the internet, provided that proper notice is given and interactive access by members of the public is provided. However, the use of an electronic bulletin board to discuss matters over an extended period of days or weeks violates the Sunshine Law because it circumvents the notice and access provisions of the Sunshine Law. The Sunshine Law is applicable to meetings between a board member and an individual who is not a member of the board. When that individual is not a member of the board, it's being used as a liaison between the board members or to conduct a de facto meeting of the board members. The Sunshine Law is applicable to investigative inquiries of public boards. The fact that a meeting concerns alleged violations of laws or regulations does not remove it from the scope of the Sunshine Law. Meetings of a public board or commission at which personnel matters are discussed are not exempt from the Sunshine Law in the absence of a specific statutory exemption. Similarly, the Sunshine Law applies to meetings of a board when interviewing applicants for positions appointed by the board, when conducting job evaluations of city employees who answer to and serve at the pleasure of the board, and when conducting employment termination interviews of city employees who serve at the pleasure of the board. The negotiations by a public board for the sale or purchase of property must be conducted in the sunshine. In addition, if the authority of the public board to acquire or lease property has been delegated to a single member, that member is subject to the Sunshine Law and is prohibited from negotiating the acquisition or lease of the property in secret. Members elect are subject to the Sunshine Law in the same manner as board members who currently are in that office. The Sunshine Law does not apply to candidates for office, however, unless the candidate is an incumbent seeking re-election. The Sunshine Law does not apply to a meeting between individuals who are members of different boards unless one or more of the individuals has been delegated the authority to act on behalf of his board or her board. An ex officio board member is subject to the Sunshine Law regardless of whether he or she is serving in a voting or non-voting capacity. Simple example of this would be a city council member who is serving in an ex officio capacity on the Planning and Zoning Board. A discussion is subject to the Sunshine Law where there is a common facilitator who is receiving comments from each board member in front of other board members. Similarly, a public forum that is hosted by a city council member with other council members invited to attend and discuss matters which may foreseeably come before the city council for action is subject to the Sunshine Law. The Sunshine Law does not prohibit city council members from attending other city board meetings and commenting on agenda items they may subsequently come before the city council for final action. However, city council members attending such meetings may not discuss those issues among themselves. Members of a public board are not prohibited under the Sunshine Law from meeting together socially, provided that matters which may come before the board or commission are not discussed at such gatherings. A key element of the Sunshine Law is the requirement that boards subject to the Sunshine Law provide reasonable notice of all meetings. Notice is required even though meetings of the board are of general knowledge and are conducted in an open manner. The type of notice that must be given is variable, however, depending upon the facts of the situation and the board involved. In some instances, posting of the notice in an area set aside for that purpose may be sufficient. In others, publication in a local newspaper may be necessary. In each case, however, an agency must give notice at such time and in such a manner as will enable interested members of the public to attend the meeting. A public agency, however, may be subject to additional notice requirements imposed by other statutes, its charter, or its code of ordinances. In such case, the requirements of that statute, charter, or code of ordinances must be strictly observed. The Sunshine Law does not mandate that an agency provide notice of each item to be discussed via a published agenda. Thus, while Florida courts have recognized that notice of public meetings is a mandatory requirement of the government of the Sunshine Law, the preparation of an agenda that reflects each and every issue that may come before the governmental entity at a noticed meeting is not. Therefore, the Sunshine Law does not prohibit a city council from adding additional items to the agenda at a regularly noticed meeting and taking formal action on the added items. Be careful, though, because the Attorney General's office has advised that a city council must postpone formal action on controversial matters come before the city council at a meeting where the public has not been given notice that such an issue will be discussed. Now, a controversial matter, for you to understand, is something that is of great import that affects a large segment of the population. In those instances, that's an urgent matter that needs to be publicly noticed before it's discussed and decided. Section 286.0105 Florida statutes requires each board, commission, or agency of this state or any political subdivision thereof to include in the notice of any meeting or hearing, if notice of the meeting or hearing is required of such board, commission, or agency, the advice that if a person decides to appeal any decision made by the board, agency, or commission with respect to any matter considered at such meeting or hearing, he or she will need a record of the proceedings, and that for such purpose, he or she may need to ensure that a verbatim record of the proceedings is made, which records include the testimony and evidence upon which the appeal is to be based. So this applies in quasi-judicial matters, and you'll see a court reporter sitting in the front row transcribing what happens at the hearing. The basis of that is, in case the applicant is denied the relief requested, then an appeal may be taken, and they will want a verbatim transcript so that the court can be apprised of that information. Where a public board or commission acts as a quasi-judicial body or takes official action on matters that affect individual rights of citizens in contrast with the right of the public at large, the board or commission is subject to the requirements of Section 286.0105 Florida statutes. The mere fact that a meeting is held in a public room does not make it public within the meaning of the Sunshine Law. For a meeting to truly be public, the public must be given advance notice and provided with a reasonable opportunity to attend. A municipality may not hold city council meetings or board meetings at facilities outside of its boundaries. Furthermore, the Sunshine Law prohibits boards from holding their meetings at any facility which discriminates on the basis of sex, age, race, creed, color, origin, economic status, or which operates in such a manner as to unreasonably restrict public access to such a facility. The Attorney General's office has also expressed concerns about holding a public meeting in a private home in light of the possible chilling effect on the public's willingness to attend. If a huge public turnout is expected for a particular issue, and the largest available public meeting room cannot accommodate all of those who are expected to attend, for example, the city council chambers, the use of video technology, for example, a television screen outside the meeting room, may be appropriate. The term open to the public as used in the Sunshine Law means open to all who choose to attend. A board's request that certain members of the public voluntarily leave the room during portions of a public meeting is not authorized. Staff members, similarly, are members of the public and are allowed to attend. Therefore, they cannot be excluded from public meetings. Reasonable rules and policies which ensure the orderly conduct of a public meeting and which require orderly behavior on part of those persons attending a public meeting may be adopted by the board. However, a board may not ban videotaping of an otherwise public meeting. Similarly, a rule or policy that prohibits non-disruptive or silent tape recording devices at a public meeting is invalid. A city may not require persons wishing to attend public meetings to provide identification, such as a driver's license, as a condition of attendance. That is not to say that the city may not impose reasonable security measures on the members of the public entering a public building. For example, requiring the public to go through a metal detector, as you would see at any courthouse. Section 286.011, Section 286.0114 Florida statutes, effective October 1st, 2013, is very important. It deals with public comments. That statute now mandates, subject to specified exceptions, that the public be given a reasonable opportunity to be heard in a proposition before a board. The opportunity to be heard does not have to occur at the same meeting at which the board takes official action if the opportunity occurs at a meeting during the decision-making process and is within reasonable proximity in time before the meeting at which the board takes the official action. Boards are not prohibited from maintaining orderly conduct or proper decorum in a public meeting. In addition, boards are authorized to adopt specified rules or policies governing the opportunity to be heard, for example, time limits for speakers, procedures for designating a representative of a group to address the board rather than all members of the group or faction, forms to indicate a speaker's position on a matter, and designation of a specified period of time for public comment. The Sunshine Law specifically requires that minutes of a meeting of a public board be promptly recorded and open to the public for inspection. Thus, a city cannot refuse to provide public access to meeting minutes until after those minutes have been approved by the City Council. The minutes required to be kept for workshop meetings are no different than those required for any other meeting of a public board. While tape recorders may be used to record the proceedings before a public body, written minutes from the meeting must also be taken and promptly recorded. Draft minutes of a board meeting may be circulated to individual board members for corrections and studying prior to approval by the board, so long as any changes, corrections, or deletions are discussed and adopted during the public meeting when the board adopts the minutes. Minutes of Sunshine Law meetings need not be verbatim transcripts of the meetings. Rather, the use of the term minutes contemplates a brief summary or a series of brief notes or memoranda reflecting the events of the evening. However, an agency is not prohibited from using a written transcript of the meeting as the minutes if it chooses to do so. There is no requirement that the tape recordings be made by the public board at each public meeting. However, if you choose that path, once made, such recordings are public records and their retention is governed by the Public Records Act and the schedules established by the Division of Library and Information Services of the Department of State. Board members are not prohibited from using written ballots to cast a vote as long as the votes are made openly at a public meeting, the name of the person who voted and his or her selection are written on the ballot, and the ballots are maintained and made available for public inspection in accordance with the Public Records Act. By contrast, a secret ballot violates the Sunshine Law. Any member of a board who knowingly violates the Sunshine Law is guilty of a misdemeanor in the second degree. The criminal penalties apply to members of advisory councils subject to the Sunshine Law, as well as members of elected or appointed boards. The governor of the state of Florida may suspend an elected or appointed public officer who is indicted or informed against for any misdemeanor arising directly out of his or her official duties. If convicted, the officer may be removed from office by executive order of the governor. A person who pleads guilty or nolo contendere who was found guilty or deemed to have been convicted, notwithstanding the suspension of sentence or the withholding of the adjudication, it's all operative. The Sunshine Law also imposes non-criminal penalties by a fine not exceeding $500. Reasonable attorney's fees will be assessed against a board member found to have violated the Sunshine Law. Furthermore, such fees may be assessed against the individual members of the board. So it's very important that you make sure that you comply with the Sunshine Law for these reasons and pay critical attention to this presentation today. The Sunshine Law also authorizes an award of appellate attorney's fees if a person successfully appeals a trial court order denying access. The circuit courts, which are the trial courts of the state of Florida, have jurisdiction to issue injunctions upon application by any citizen. Although a court cannot issue a blanket order enjoining any violation of the Sunshine Law on a showing that it was violated in particular respects in the past, a court may enjoin a future violation that bears some resemblance to the past violation. The future conduct must be specified with such reasonable definiteness and certainty that the defendant, meaning the public board or the public board member, could readily know what it must refrain from doing without speculation or conjecture. No resolution, rule, regulation, or formal action shall be considered binding except as taken or made in an open meeting. Therefore, where officials have violated the Sunshine Law, the official action taken is void ab initio, a Latin phrase meaning from the beginning. Where, however, a public board does not merely perfunctorily ratify or ceremoniously accept at a later open meeting those decisions which were made in an earlier secret meeting, but rather takes independent final action in the Sunshine, the decision of the Board or Commission will not be disturbed. The only remedies available pursuant to the Sunshine Law are a declaration that the act taken was wrongful and void, and reasonable attorney's fees. Money damages are not a remedy provided for by the Sunshine Law. This concludes my presentation on the Sunshine Law. I appreciate your time. It's invaluable. Thank you so much. Have a blessed day.